teacher in K through 8 system. So this work sounds like it's going to be a fascinating talk. I heard you speak at one of the faculty meetings. I was really fascinated by the method and the sort of getting at these really deep-seated issues, intrinsic to the individual, right? So Ariana is going to speak on vulnerability and legality in ethnographic fieldwork. And she draws from the field of language socialization and linguistic anthropology to examine how an individual's linguistic and cultural development is shaped by citizen status. And that's a really interesting topic right now, given what's going on in our country. She is a recipient of the NAED Spencer postdoc in 2013 and 14, and her work has appeared in Anthropology and Education Quarterly, Language Policy, and has something forthcoming in the American Educational Research Journal. So join me in welcoming Ariana.
Thank you. So thank you, Janice, for inviting me to talk today, and Erica for arranging my brown bag presentation. I appreciate having the chance to share my work with all of you. The ideas I'll present today share 3 characteristics that may seem at odds with each other. They're longitudinal yet new. They issue from a decade of work in mixed status communities. And while I've been thinking about these issues for some time, this is the first opportunity I've taken to share this particular talk out loud. They're interdisciplinary yet anthropological. So I'll mention the law, psychology, music, and policy. But at the core, these questions arise from my study of language and culture. And they're professional and personal. While our social science methods, texts, and approaches suggest that we should try to disentangle the two through qualitative approaches such as bracketing and memoing, for example, in my life as an educator and in my academic training, they've always been inseparable. So these are all tensions I grapple with in my work, and this particular paper is a work in progress. So I'm looking forward to your comments and questions, because I know they'll help sharpen my thinking moving forward. So this talk draws on my fieldwork in mixed status communities from 2008 through the present. In these immigrant communities, some members have legal citizenship status, either because they're U.S.-born citizens granted birthright citizenship under the 14th Amendment of the U.S. Constitution, or because they acquired lawful resident status, colloquially known as the process of obtaining a green card. Others may have temporary status obtained through work or student visa. And still others may be undocumented immigrants because they've overstayed their visas and lost legal status, or because they entered the U.S. without legal permission. And these categories aren't static, so an immigrant may have different legal statuses over the course of the time they reside in the U.S. The majority of the families that I've worked with in California, Pennsylvania, and New York have been from Mexico, with others hailing from Central American countries such as El Salvador and Guatemala, and from the Dominican Republic and the Caribbean. And here's a genogram borrowing from psychology and family systems approaches to representing relationships of a typical mixed status family that I met conducting dissertation fieldwork in Pennsylvania. This genogram also represents broader trends in immigration in the U.S. The parents in this family immigrated from Mexico, leaving their homes because of extreme poverty and in cases of other families' violence as well. So in this family, which I call the Utuado Alvarez family, an older child named Amaris, you can see her with the dotted line, continued living in Mexico and was being raised by grandparents. Her mother, Marta, hoped that she could one day come to the U.S. as well. The parents, Marta and Carlos, lived with their undocumented 8-year-old son who crossed the border from Mexico into the U.S. with Marta, and their 4-year-old U.S.-born citizen son. So one thing I've done in using this genogram in my work, this approach, is I've added in that shading, which denotes citizenship. So you'll notice that in this sort of nuclear family unit, the only one who currently has U.S. citizenship is the youngest born. And I use that because it sort of mirrors the way the families talk about it, right? So they also say that they tend to talk about privileging having the U.S. citizenship, right? Anything else is a lack. Even though they don't lack citizenship from anywhere, they have Mexican citizenship, but they don't have the U.S., right? So in most families I've known, the older children were undocumented and the younger children were U.S. citizens. This is because since 2000, the rise in the Latino population has resulted from undocumented migrants giving birth to children in this country, rather than rates of migration from Mexico to the United States. So despite the anxiety and the hysteria produced by ongoing and now heightened political threats of building a wall to barricade Latin American immigrants out of the U.S. along the southern border, border crossing has actually been on the decline for nearly 2 decades. And I think it's worth debunking another myth here one that's often applied to families like this is this term anchor babies, right? And undocumented parents with U.S.-born children don't bear these children in the U.S. in the hopes of immediately gaining access to social services and legal citizenship. Children born in the U.S. are granted birthright citizenship, but they cannot apply to legalize their parents' undocumented status until they turn 21. Even if and when they were to complete an application, their undocumented parents would be subject to intense scrutiny and experience long immigration backlogs like other applicants. So the families I know risk their lives on a daily basis to provide for their children in families with no guarantees of obtaining legal citizenship and the rights that attend it. And these days, the families I know live with much more fear of incarceration and deportation than hopes of immigration reform. So as an educational anthropologist, I spend sustained time in homes, schools, and communities conducting participant observations. I audio and video record interactions between focal children and their peers, teachers, and family members, and I collect artifacts of student work as well as those documents that travel between public institutions like schools and the family's homes. So this kind of triangulation allows me to understand, as Janice was so generously saying, the ways in which citizenship comes up in their everyday lives and the effects this has on how they participate in schooling processes. So here are a few examples. That middle bottom one is a video still from recordings in one family where the 6-year-old U.S.-born boy, this was my second visit to the home, introduced me to his family by going to a corner of the house that was on a hook, there was a bag, and he took the bag off the hook and proceeded to take out all of the different family documents, passports, consular identifications, and he did so in order to introduce me to the family, to say who had papers, who didn't have papers. This is a 6-year-old. While his older undocumented sister sat looking on, right? So one of the things I've learned through this work is that children of all ages really schematize their world based upon citizenship status. The top right there is a form shared with me by an undocumented mother. She needed to complete this in order to enroll her children in free and reduced lunch in that program at school. The form requires parents to enter the last 4 digits of their social security number, or indicate with an X in the sort of bottom part of the form if they don't have one. So the mother was hesitant to complete it despite the much needed help that the free lunch program would provide. And so another one of the lessons from this work for me has been the ways in which schools unwittingly, in many cases, actually end up being aligned with immigration and enforcement policies, even in an effort to protect the invisibility of status, right? So by putting an X, she felt she was still disclosing something, right? A lack of something. And then finally, that top left there is a poster with a group brainstorm completed in school where students were asked to define the word diversity. When peers in this particular group mentioned border crossing and immigration as part of the classroom diversity, one undocumented focal student refused to write those terms on the poster out of fear of broaching issues of legal status in school. A longer exploration of that and other instances is what's appearing in AERJ in the next issue. So before I say more about the ethical issues that arise when working in mixed status homes and classrooms, I'd like to play a song. One that I sing on most nights to my daughters Lucia and Marcela as a lullaby. And the lyrics are adapted from a poem by Venezuelan poet Aníbal Nazoa, and they were popularized by singer Soledad Bravo in the early 70s. Bravo is a Spanish-born folk singer who spent most of her life in Venezuela, and her music formed part of a period in Spanish and Latin American cultural history known as La Nueva Canción. And La Nueva Canción, or the new song, is a genre of folk music with a political message. It was especially important in the 70s and 80s because its singers put to music many of the social messages underlying the social revolutions of the time. You may know of Mercedes Sosa from Argentina or Silvio Rodriguez from Cuba, who are sort of two of the more prominent singers of the genre. And while Soledad Bravo may be less known to some, her lyrics circulated widely at the time, and so I'm using this song as a framework for the themes I'll talk about in the rest of the presentation. Can you see that text somewhat? Let me see if I can do a quick... I've translated them for you, so I want to be sure that you could see them. See if I can just enlarge a bit. think that'll help with it. So because it's sort of the guiding metaphor, let's keep those up here as we
Entre tu pueblo y mi pueblo hay un punto y una raya. Entre tu pueblo y mi pueblo hay un punto y una raya. La raya dice no hay paso, el punto vía cerrada. La raya dice no hay paso, el punto vía cerrada. Y así entre todos los pueblos, raya y punto, punto y raya. Con tantas rayas y puntos, el mapa es un telegrama. Caminando por el mundo se ven ríos y montañas, se ven selvas y desiertos, pero ni puntos ni rayas. Se ven selvas y desiertos, pero ni puntos ni rayas.
last
Porque esas cosas no existen, sino que fueron trazadas para que mi hambre y la tuya estén siempre separadas. Para que mi hambre y la tuya estén siempre separadas.
So I've had that song on my mind a lot recently because I sing it to the girls, and it struck me in preparing for this talk that the themes that she raises are actually quite relevant to the things I've been thinking a lot about methodologically. So I hear this song as a metaphor for the ways in which societal practices and policies create distance and alienation between members of the polity. And I also hear it as a call for rethinking those divisions, even when, or especially because, they become so naturalized, right, in our everyday lives. And this, the ways in which the social distances between researcher and research become ingrained in social science research, is the primary subject of the rest of my talk. So given my research in mixed status communities, this song and the broader question of potential distances and connections raise the following questions for me. How do methodological procedures aimed at protecting vulnerable research populations from harm shape our perceptions of and relationships with study participants? And then how might our sense of connection to and solidarity with our research subjects shift if we thought of ourselves as legal subjects? That's the part that's newest for me in a sense. I've written some about the first one, but in this talk I'm really sort of thinking through the moments where I myself have become a legal subject in the field. So I would love your thoughts on all of it, but that in particular. So in order to conduct qualitative research, federal law mandates that researchers obtain IRB approval, Institutional Review Board approval. And as part of this approval process, researchers must articulate the risks and benefits that their studies pose to potential participants. When evaluating applications to conduct research with human subjects, IRB committees tend to focus on whether the study provides direct or indirect benefits to participants, and whether these benefits outweigh any potential risks. These concerns are encapsulated in the concept of beneficence, defined as, quote, an obligation on the part of researchers to do no harm, maximize possible benefits, and minimize possible harms. Once IRB approval is obtained, the researcher must share information about risks and benefits with potential participants. And this is an essential part of the informed consent process, in which the participants are given an opportunity to evaluate what's at stake in joining a study. Recent ethical violations in biomedical research, along with changes in federal educational policy, have led IRBs to focus their reviews more on the possible risks than the potential benefits posed by qualitative research in particular. However, many of the kinds of concerns in biomedical research, lack of informed consent regarding physical risks that could lead to death, for example, malpractice, conflict of interest, such as owning stock in private companies funding research, aren't, in my experience, as relevant to social science research funded by foundations or nonprofits, in which risks like benefits tend to be more diffuse, right? So in my case, the risks tend to focus on things like discomfort due to the presence of a video camera versus potential risk of death because of an allergic reaction to a drug. Right? Much of the focus in obtaining informed consent is on protecting research participants from consenting to something they may have not fully understood, from being coerced into participation, and from having their identities revealed if confidentiality and anonymity are not preserved. Considering procedures for accessibility and privacy are especially important when working with vulnerable populations, which includes but is not limited to the list presented here, which was taken from the website of the Rutgers Office of Research and Regulatory Affairs. In the case of mixed status communities, these concerns are heightened in many ways, and the process of informed consent is essential. But as I mentioned, I've become equally interested in those moments in my research when I became aware of myself as a legal subject, and potentially a vulnerable one. And I find these moments interesting because they raise questions about how a shared vulnerability with my participants could lead to more social solidarity between myself and them. Despite the IRB's focus on risk management and liability, I had never really thought of myself as a legal subject during fieldwork until more recently, even though considerations about my participants as legal subjects were always present. As a Puerto Rican researcher born in New York City, I have U.S. birthright citizenship, and while my membership in a racialized, criminalized, and police community means that I've had over time an uneasy relationship to law enforcement, the privileges of being a highly educated member of the professoriate has mitigated some of that tension in my everyday life. So as a researcher, I never thought of myself as a legal subject in the field until I reflected on some of this work I'll share. I'll offer two examples that sort of demonstrate when this shift took place. The first arose when undocumented parents asked me to adopt their undocumented son in the hopes of obtaining U.S. legal citizenship. And the second arose in the face of anti-immigration laws that make it a crime to harbor, quote, undocumented immigrants. So I'll describe each scenario in turn. In 2009, I was conducting dissertation research in southwestern Pennsylvania, and I'd become very close with the 4 mixed status families in the study. One of these families, headed by Marta and Carlos, who were the heads of the household represented in the Genogram earlier, were extremely concerned about mitigating any risks that their children might carry as undocumented children, particularly the 8-year-old. So towards the end of my study, the parents explicitly asked me to help them find a legal solution to the problems associated with mixed status, and they proposed that I adopt their 8-year-old son. And their hope was that I would adopt their son, and that in so doing, he'd be able to obtain U.S. citizenship and all the rights associated with that. And while I knew that it wasn't feasible for me to adopt a child at the time, I didn't even know if it constituted something actionable, right, if it was even a possibility. So I started asking immigrants' rights and civil rights lawyers, and this is what I learned. So of the 3 ways in which international adoptions for immigration could occur, this one would most likely fall under the category of immediate relative. And this process would entail an extensive application that would include needing to verify information about the child's life and family. And the application would have very likely required me to verify my relationships to the child and to affirm as one of the criteria that I'd had at least 2 years of legal and physical custody of the child prior to adoption. And like applications filed by spouses who petition for their husbands or wives to obtain citizenship, this process would have been subject to Title 18 of the U.S. Code of Law regarding criminal procedures. So under Title 18, Part 1546, it's a felony to falsify any immigration documents, including an immigration application. So the law reads, whoever knowingly forges, counterfeits, alters, or forcefully makes any immigrant or non-immigrant visa, permit, border crossing card, alien registration receipt card, or other document prescribed by statute or regulation for entry into or as evidence of authorized stay or employment in the U.S. So the verbs being, right, whoever knowingly forges, counterfeits, alters, or falsely makes claims, shall be, going down, fined under this title or imprisoned for not more than 25 years. And the lawyer said, well, it depends on which judge you know and how it would be argued, but essentially it's something that's still prosecutable and not a good idea. So unbeknownst to me, Marta or Carlos, the parents, the proposed adoption process could have been punishable, right, with jail time of up to 25 years. So I'll note here that while I did not ultimately agree to adopt the children, nor would I have ever falsified immigration documents to do so, I've continued to reflect on this exchange, right, as I've written about the family and the findings of my research. And to me, what's significant, in addition to the complexity of the request and how it is that they came to feel comfortable asking me as an ethnographer, right? I think there's something particular about that relationship that allowed them to do this. In addition to all of that, what's notable to me methodologically and ethically is that I was wholly unprepared to address this request, right? And I think part of that is that because our methodological considerations of beneficence, where we calculate risks and benefits, they take place prior to conducting fieldwork, right? So we outline those potential procedures and anticipated risks and benefits, and we consult with IRBs, who are very thoughtful individuals in my experience in many cases, but we do that before we get into the field. And so part of what this taught me was that in some ways we may not know what the risks or benefits will be for participants or for ourselves until we're in the field, right? And so I found that by front-loading our conversations about ethics, we rarely acknowledge or incorporate insights that we might gain about reciprocity or risk-taking throughout the study itself, right? So we'll leave that there for a second and come back to it. My second example concerns the effects that anti-immigration laws on a state and federal level can have on the researcher's ability to develop relationships with her participants. And in a way, this is less about the particular requests that participants or family may make, and more about the ways in which the socio-political and legal context may force ethnographers to rethink the very basic research activity they participate in. And I started thinking about this in 2011 when Alabama's House Bill 56 was signed into law. It's known as one of the toughest anti-immigration bills in the country, and it should be understood in the sort of trajectory of anti-immigration laws that have been enacted at the state level that now have become prototypes for what's happening at the federal level. Chris Kobach, the Secretary of State of Kansas, has been intimately involved in authoring and defending state laws originating in Arizona in 2010, known to activists as the Show Me Your Papers bill, which raised real concerns about racial profiling, leading to detention. Alabama and 4 other states then enacted copycat laws, and Alabama is the one I'm describing here. Kobach is now, as many of you know, one of Donald Trump's primary advisors on immigration. So one of the things the Alabama law does is it makes it a potential crime to act in ways considered to be, quote, harboring and transporting any undocumented immigrant while knowing or recklessly disregarding the fact that the alien has come to, has entered, or remains in the United States in violation of federal law. This is the ACLU's analysis of the law. And as they explain, quote, such activities can include driving someone to a doctor, to a church, or to a grocery store, which is then punishable by time in prison or hefty fines, depending on the severity of the crime and the number of individuals being harbored. So the punishment can increase if it's after harboring, if it involves 10 or more undocumented migrants, or in the law what's known as aliens. So this notion of harbor, right, had caused an uproar from civil rights groups and from members of the Alabama clergy in 2011 when the law was passed, because providing transport and safe haven can be 2 very common functions performed by churches working to provide sanctuary for those in need. They're actually, it turns out, integral parts of the life of an ethnographer, right? I routinely gave families car rides in Pennsylvania, and I, on a regular basis, can be found to be in transit with members of mixed status families in my fieldwork in New York City. But I've never put into place protections for myself or them in the event that I was conducting field work in a place where those laws could incriminate me. I, last week in preparing for this talk, had a conversation with one of the IRB staff here at Rutgers, and she advised me to think through what kind of story I might tell police if I were stopped while traveling with an undocumented study participant, right? So imagining potential storylines that were just friends, putting into place protections where I would never have any reference to the study or the data on my person. But it raises real questions, right, about what the impact of telling such a story would be for me, for the participants, and for the research in general. I'm not a very good liar either, so my first recourse. So the socio-political landscape in which ethnographers and social scientists are now working is shifting so rapidly that IRBs and researchers alike are working to generate new protocols and procedures to address these kinds of dilemmas. In this historical moment, these types of concerns have become more real than hypothetical. As these headlines from The Atlantic, The Washington Post, and Univision indicate, the new administration seeks to extend, and just issued a set of memos providing guidance on this yesterday, seeks to extend the jurisdiction of immigration officials by incentivizing local law enforcement to work in tandem with them. There were a series of initiatives that aren't new, actually, that were begun during the Obama presidency, but which he scaled back considerably after outcry from immigrant and civil rights groups about racial profiling and the like. In this moment, the notion of offering sanctuary has also become a center part of the policy debate. And yet, in some ways, there are some even more basic threats to the integrity of citizenship that are on the table, questions that precede or parallel this discussion of sanctuary. And so two of these basic conditions surrounding citizenship and schooling in particular include the following. In recent years, increasing numbers of prominent Republican congressmen have called for the repeal of the 14th Amendment of the Constitution, which grants birthright citizenship in this country and which was born out of the emancipation of slavery. On the campaign trail, Trump questioned whether U.S.-born children of undocumented immigrants were actually citizens, which of course they are, according to the 14th Amendment. This important part of our Constitution has also served as the basis for the Plyler versus Doe ruling, right? The Supreme Court ruling in 1982 that guarantees all children, regardless of their or their parents' birthplace, the right to K-12 public schooling. And that second sort of set of images there was a leaked memo from the White House that came out and was analyzed last week, about 10 days ago, analyzed by the Migration Policy Institute in Washington, D.C., that suggests that in an effort to increase the number of deportable individuals by at least about 4 million, the new administration may broaden the criteria for deportability to include legal immigrants, green card holders. And one way to do so would be to amplify the definition of public charge, someone who uses public services, to include something as basic as free and reduced price lunch in school. So in an attempt to sort of broaden that, there are existing mechanisms by which someone who is deemed a public charge, right, can be deported. But it's been very circumscribed by how much time they've been in the country, what sort of their legal status has been. And so in this leaked memo, which again hasn't yet been acted upon, but the concern is that by amplifying the definition of public charge, it could start to include things as very, very basic as having ever gotten free and reduced price lunch in school, which loops us back, right, to that opening set of slides around moments when mothers have been fearful in my presence of what forms to fill out in school and what services to access. So I could enumerate other attacks on citizenship, and I'm sure you could too, and the Constitution being made at this time, but I think these are the most relevant to mixed status families, and I think they're sufficient to exemplify the growing linkages between immigration and education, policy, and policing. So I'd like to return to the Soledad Bravo song, the line in which points and dots, or those things that keep our hungers, fears, and lives separable, fueron trazadas, or were drawn. And in being drawn, that means they're also retractable. Right? They're not natural, they're social, they're constructed. So rather than retreating from the vulnerable populations that we work with, I hope that we actually will go towards them and move from thinking about fears of liability to opportunities for solidarity. And I hope that we can create this multifaceted, concerted effort, one that begins with humanity and then extends through all of the research procedures, both on and off campus, that we engage in. I look forward to learning more and thinking more with all of you about how this might be possible in our research, writing, and scholarship. So thank you.
Thank you. Great. Questions?
Ariana, you and I briefly talked before this, and I just submitted a piece to QSE last week on negotiating this new environment. And one of my big worries is Plyler versus Doe. It's a 1982 case. The Supreme Court, it was a 5-4 decision. And except for issues on like queer rights, and that's all tied into whiteness, the Supreme Court is far more conservative today then, so I don't know if Flyer v. Go would actually be upheld if litigated. And there are all sorts of ways where the feds, because of the power of the money, particularly in urban districts, which states have disproportionately underfunded, can actually turn public school leaders into mandated reporters for immigration. And so, you know, your form on the free and reduced lunch form is one way where they could just go through their archive of forms and now be compelled to report status to the federal government to the best of their ability upon pain of losing all their federal money if they don't report. And that's the big stick at play. For universities, this could also play out in a whole host of ways. One of the things that's coming up before the Faculty Council is under the new Rutgers all-encompassing email system, they have basically not quite total carte blanche to comb through our emails if you use a GSE account. So what if you're working with populations that are undocumented? You know, are the feds going to say to the university, upon losing all your federal grant monies, tax status, et cetera, the feds can play a really big stick, cough up all your materials on undocumented students and populations, et cetera. Now, granted, I'm kind of following this argument to its most extreme, but I spent the summer reading European history, particularly from about 1914 to 1946, and scared the bejesus out of myself, because particularly around this issue of migration, which was a key factor in 2 world wars. And who was a citizen, who had the right to citizen, it was always up for grabs as maps were drawn and redrawn and fought over. And who's a real German? Who's a real Soviet? Do you mean Soviet or do you mean Russian? Yeah. And so because we are government agents, we are all government agents. We are at the State University of New Jersey. Our own role as, you know, I really worry about us all becoming mandated reporters when it comes to immigration status. And I'll just leave it at that.
Thank you.
And the public school principals with whom I work.
Right. Thank you. I think you raised 2 important considerations. One is, you know, there is a lot of conversation, you know, about sanctuary. And I think the big question is, to what extent would institutions, communities, cities, municipalities, right, be able to uphold those ideals in the face of already dwindling resources and right, the money versus the sanctuary in a sense. There's that piece. And then the other thing is, you know, I've learned about it in the last few years has been this certificates of confidentiality that the NIH gives. It's just worth sort of noting it, since this is also a talk about methodology. So if you are, you know, putting in an application for IRB to work with vulnerable populations, and not just undocumented ones, but ones that are particularly considered legal subjects, you can submit an application to the NIH for a certificate of confidentiality, which would mean that you have to sort of argue for that on the basis of some kind of risk, physical risk, mental health. But it would essentially, if you were granted that, and you could be denied it by the NIH, it would mean that the records and your data would not be subpoenaable.
Very good.
So that's another, you know, consideration, sort of layer of protection. Yeah.
One of the things, I've had some conversation with some of the community organizations in New Brunswick, and there's been this big push for New Brunswick to declare themselves a sanctuary city, even though they have a number of practices in place. But there was a kind of negative article printed in the Targum about the mayor, and then he came out with a statement that clarified some of the things in there. But they've been really pushing for them to kind of put this, at least in names. And one of the things they've raised is you'd be much better to be a undocumented immigrant in Middlesex than you would be in Hudson County. So even if you're in Jersey City, which, as you said, they're a sanctuary city, if you get into the county system, they actually have ICE in the prisons. Whereas Middlesex has no agreement between the county and ICE, and so a lot of that, a lot of the access through the legal system isn't necessarily through the city in New Jersey. A lot of it's through the county, and so you could be in Jersey City thinking you're safe, but if any sort of interaction with the law happens, you actually could really be much more vulnerable than you think, as opposed to being in Middlesex. Even though New Brunswick hasn't put the name on it, they do a lot of the practices, and there's some a little bit of debate on it, but I think most people are in agreement, even the people, the organization sometimes protest. And so it's a interesting kind of nuance to what that term means and what it really grants you.
And where the power resides, right?
Yeah.
I think that's one of the things I've been learning a lot about particularly in conversations in the last few weeks about these issues is almost sort of doing like a new social mapping in this historical moment of where that power resides, and where as researchers and activists where our efforts would be best placed, right? So is petitioning at the city level actually the most strategically useful? I think it's various, but I think that's an important question, right?
Yeah.
To have.
And my guess is it varies by state,
Right.
Like being in New York City, city level might work. I don't know, right? But in New Jersey in particular, it seems to be a different case.
That's right. Thank you. Thank you. Yes.
Yes, good afternoon. Sorry for being so intrusive. My name is Lily Sanchez, and I'm using Dr. Belza's invitation to observe your lecture.
Welcome.
I work for Essex County College. I'm the bilingual / undocumented student / community activist for pretty much the undocumented students on that aisle. Lots of my students transferred to Jersey City University. Some of them cried when the police went to Jersey City and actually say that they were close to Hudson Community College, pulling them up. Some of them called me from Elizabeth 2 or 3 days ago because I work with the consulates as well. So the Consulate General of El Salvador, in Colombia, and Ecuador, and we're constantly communicating with each other because we work in the same community basis. And this whole sanctuary thing, it's my humble opinion, forgive me, I beg of your pardon. It's confusing when, although we do it at the cities, and mind you, as activists, I think we're doing it right. Geographically, we have to go to the cities to be able to work the borders within cities to make sure that if you're in Newark, the Elizabeth town, it's okay for those undocumented to pass through cities safely. How does that impact the state? Recently, when we were questioning the constitutional rights of these agencies to intrude in community colleges, I came to the abrupt realization, and this is with my friends that are lawyers as well, that although there is the notion that schools and colleges are sanctuaries, legally, and this is a question in the state legislation at this time, legally, it's not. Right. So although we're doing our grassroots work at the cities, until we don't impact and we don't make sure that there is something in legislation that is a mere formality, that is a policy, what good does it do us? And a lot of people says, yeah, but New York City did it. Yeah, but New York City is a touristic machine that can tell to the federal government to screw themselves if they want to. But they have their own resources to replace federal funding. We don't. We're not a highly touristic place that people are going to come and like spend their dollars here. So how do we go about that? It's a lot of things that we have to do, but I think that we have to do a larger work on communicating the East with the West of this state. I think it's awesome, and I want to thank you very much. The last fall protest that I went to, which was in Rutgers University, Newark, I saw many of you attending, and thank you, because many of the locals didn't go. So you'll be doing the work that many of us cannot do. And mind you, I'm saying that they cannot do, because undocumented cannot do their own protest. But what is the link of Middle States? What is the link of Mercer? What is the link of, and there are groups within the groups that are hitting on their own towns, and they don't even want to come out. Why? Because they still with the fear that at least Newark is hit, or Jersey City is hit with all these ICE, attacks and whatever, but we have immigration lawyers and where to run to. In these far communities, the help, the type of open assistance is a little bit more mild, and therefore, it's less, less frequent. So, do we need to do a greater amount of communicating with the counties, between counties and between cities, and between community activist groups? Absolutely. I think this is definitely the time to start talking to each other. And there is a power of saying, and forgive me, I don't mean to be insulting to anybody, but what a powerful statement is when a white person claims for my rights. And I want to remind you that the 8th of March is also the Women's March, and I hope all of you gentlemen to see you. Thank you so much.
Thank
Sorry
you.
about that.
Thank you. I appreciate that. I was at a working group meeting this past weekend in Washington, thinking about, it started really, it's been meeting for several years and convened by Kenji Hakuda and others at Stanford, and thinking really largely about English language learners and policy, and the opportunities provided by reauthorizations of ESEA and now ESSA. But with the election and the results and the real exigency around immigration as an overlap, although not intrinsically a correlation to language learning, but the relationships between the ELL community and the immigrant community, they invited sort of young scholars who were working on immigration to be part of the conversation. And there were some of the lawyers who argued for Plyler, and some of the staff at the Migration Policy Institute and other places that are providing an analysis of the memos that are coming out of the guidance for how to enact the new immigration executive orders. And the big question sort of for everyone on the table is what can the work of academics, of researchers, what can our contribution be to that conversation? So I would welcome thoughts from you, Liliana, from others too. That's the question I have very present on my mind, as we go back to, and I offer myself just as a way of thinking through this stuff, not because I think it's the most useful or the only, research by any means out there, but on these children. But when I think about these pieces of evidence, right? So, so we think about the school and reduced lunch forms as a place where families fear doing some implicit disclosure of status, because as I was saying, Liliana, in New York City, you are required to put the last 4 digits of your social, but if you don't have it, you put X's. So in some ways, the implication is you're undocumented, right? If you're not.
Right.
But parents are filling out, of course, the forms in mass because they are living in poverty, essentially. And so, so what is the place of this kind of evidence in, that cross-county collaboration, those new, junctures for advocacy and change? That's really an open question for me. Yeah.
I have an odd question.
Mm-hmm.
Is faking illiteracy a crime? And why? Because of all the federal forms and various forms folks have to sign out. And I come from an area where illiteracy is an ongoing issue. What happens? You have a friend who fills in the names, but when it comes time for like social and your signature, you just X as much as you can. To make it a bit more supposedly apparent that you might be illiterate. I don't think illiteracy in and of itself, whether you fake it or not, is a criminal offense. And that might be one way to subvert the paperwork.
I think that the paperwork would get kicked back.
Okay.
So it's not when you sign and say to the best of your knowledge everything here is true,
Yeah.
in that way you're lying. But also if the form is incomplete, bureaucracies will just kick it back and say we'll get someone to help you with it. So unfortunately, it sounds like a good idea, but I don't think it would work.
interesting because illiteracy is one way to petition for amended informed consent procedures, right? So you can orally consent someone if they aren't going to be able to sign.
Right.
And you can make an argument for orally consenting members of undocumented communities and studies because of this privacy, question.
Yeah, so I've been getting more involved in this work around how research is used to influence policy. And one of the most compelling ways is through stories, right? And it seems to me that, there's this real tension here because we have to communicate these stories of real people to bridge the distance and the alienation that exists. And, in the easy ways people can alienate themselves from other people. And yet, you don't want to compromise folks either. And so, I don't have the answer, but it just strikes me listening to this that's just a real tension that we've got.
Yeah, and I've always thought about sort of like in the training and the early years of academia, thinking about publishing as an educational anthropologist. My big tension around storytelling has been around and policy or narrative, right? And policy is this N of one compelling enough, right, to make policy decisions and in some ways I feel like the conversation has shifted in the last couple of months around not so much if it's compelling, but where to put those stories. Right.
So it's all about these intermediaries so it's not that you have a better journal.
Right.
That's not going to shift it. Right. But it's how does it get then communicated, translated into something that makes it to the audiences.
Exactly right. Exactly.
Well, and we've got 40 some years of, how much do policymakers look at research? And, the findings are absolutely dismal. One, it has to align with their ideological preferences. If it doesn't ideologically align, they're not going to read it.
Same with stories, too, because for every one kind of story, you can find another kind of story.
Yeah.
And Trump can tell stories of undocumented workers who are criminals, and we can tell stories of undocumented workers who are not,
Right.
So how do we make our research, which is factual, as opposed to these delusions, amenable to policymakers? And it's tough because they'll run right to the think tanks, which just churn this crap out at quite a pace. So we are pushing uphill. I don't want to argue against just giving up, but also I did a book on kitsch and public policy about 20 years ago, and politicians also use all sorts of tacky art forms to justify their policy preferences. So I expect, like Chris Kobach will roll them out as well. And so not only do we have no research, we have these cultural icons that get invoked that are very powerful, and how do we beat those down?
And then how to, there's no pure narrative, right? So, one of the things that people have, been talking about for a long time now is how there's the discourse of the good immigrant and the bad immigrant, right? So in arguing for the educational rights, for example, of the children, and, Plyler obviously is a case, and the lawyers of Plyler are folks I admire tremendously, but one of the ways they argued it was to say, the Justice Brennan in his opinion wrote, no child should be held accountable, essentially, paraphrasing, for the burden of a legal characteristic over which they had no control, right? So don't blame the kids for their parents' criminality, basically. And, of course, that helped to leverage rights to K-12 schooling and otherwise, but thinking about how to tell a story that doesn't just doesn't sort of scapegoat one member of the household for the rights of the other three, or, so on. So how to tell a story that it's complex enough, but also hearable, right? Exactly. Yeah.
It also makes me think, so you do have a story, but you also have something systematic within the district in terms of these forms, right? And so, irrespective of convincing people one way or another, helping people